This video is Expungement, When Can You File for Expungement? Brought to you by the New Mexico Judiciary and presented by Ryan Bachman. The information presented in this video does not and is not intended to constitute legal advice. All information in this video is for general informational purposes only. Information in this video may not constitute the most up-to-date legal or other information. Viewers of this video should contact an attorney to obtain advice with respect to any particular legal matter. Only your individual attorney can provide assurances that the information contained herein is applicable to your particular situation. The views expressed in this video are those of the author or authors only.
It's important to know what effect an order to expunge has. An order to expunge can be entered, and the arrest record of a criminal proceeding shall be treated as if it never occurred. And this is treated this way to the general public. Now, courts, law enforcement agencies, and other criminal justice agencies, they're still going to have access to these records. So keep in mind, if your record is expunged, that record is not destroyed. These records are kept by law enforcement agencies, and arrests or conviction records may still be available for use in future criminal proceedings. So that is one important distinction to know about expungement, that although these records are treated as if they never occurred to the general public, and if the general public inquires about these records, these agencies are going to respond that no such record exists with respect to this person. Finally, these records, given that they're not destroyed, is the removal of access of arrest records from the general public. So these arrest records include any notations of arrests, plea agreements, convictions, acquittals, or even dismissals of charges. These records are generally available to the public. They can be posted on court websites or law enforcement agency websites. So in a nutshell, the effect of an expungement is that your arrest record will not be generally available to the public. Now, and the effect of an expungement order, although these records are not available to the general public, courts, law enforcement agencies, and criminal justice agencies will still have access to these records. These records are not destroyed. They're kept by law enforcement, and they can be used for the purposes of a future criminal prosecution or proceeding. The importance of an expungement, however, is that if there is an inquiry to any of these agencies from the general public, these agencies are going to respond that no such records exist with respect to this person. So with regard to expungements, the courts have generally grouped these into three different types. There are expungements for records upon victims of identity theft. There are expungements in which a person was released without conviction, and there are expungements for people who were convicted and later released. Now, these are all treated differently. For example, for an expungement petition upon identity theft, there is no waiting period. A person can file for or petition for an expungement at any time. For a release without conviction, there is a 1-year waiting period before you're able to file a petition for expungement. And this waiting period begins after the final disposition of your case. The final disposition isn't necessarily your last court date. The final disposition could be after a period of a wait time. For example, if the person received a deferred sentence, which generally is an agreement between the prosecutor, the courts, and the defendant that the person agrees to stay out of trouble for a set amount of time, then their case is dismissed. In that instance, that would be the final disposition of their case. The third and possibly most complex type of expungement is expungement upon release with a conviction. Now, not every crime that a person is convicted of is eligible for expungement, but if a person is eligible for expungement, they must satisfy certain waiting periods. Those waiting periods are 2 years if the conviction relates to a municipal ordinance or a misdemeanor, 4 years if the conviction relates to a misdemeanor conviction of aggravated battery, or the conviction relates to a 4th-degree felony. The waiting period is 6 years for 3rd-degree felony convictions, 8 years for 2nd-degree felony convictions, and lastly, the waiting period is 10 years if the conviction relates to a 1st-degree felony or any crime that is provided under the Crimes Against Household Members Act.